to remove.
Yeah, the top one, yeah, they call, yeah, I took it out.
Hearing me okay, Ms. Jefferson, are you able to hear me?
Yes, I can hear.
All right, very well. So anybody here on Visiting Angels, do I have Kenneth Wesley or anybody on that case?
Yeah, Mr. Washington is here, Your Honor.
All right, your appearance at this time, sir.
Okay, Jim Washington, I, P42503, I am appearing on behalf of the plaintiff, Visiting Angels.
All right, thank you. For the defendant in this matter, your appearance at this time, please.
Good morning, Your Honor. Thomasine Jefferson on behalf of the defendant Kenneth Wesley, P42872. Thank you.
All right, thank you. Good morning to both of you. Kind of a running kind of morning, so a little bit behind. Thank you for your patience. So somebody update me on where things are in this regard. I know the last time you were here, parties were trying to reconcile some records to see if this could resolve.
Yeah.
Somebody talk.
Yes, Judge. We were just in the breakout, and since the last time we were here, it appears that everything is now turning on the VA payments being credited against the charges. And we've agreed with Miss Attorney Jefferson that we're willing to sit down either by Zoom or a meeting with the clients. We'll bring our docs to establish what we have in terms of the VA payments. And then, of course, they've indicated that if that's the case, if we're able to show that, then they should be able to understand that maybe these monies are due. And if not, then we accept the burden of proving that the VA payments have been duly applied. So I don't have a problem in terms of what Ms. Jefferson has asked me to do. And if that's the case, I think it's going to turn on whether we can establish that those payments have been duly credited and are due to be paid to my client or not. I think that's a fair statement, Ms. Jefferson, what you indicated, and I indicated.
That's correct, Your Honor. It seems that the monies that they are requesting are the total. It sounds like the total would be VA monies. Either VA paid them or they didn't pay them. If not, we will assist on them in getting VA paid. I mean, getting them the VA monies.
All right. So you believe it sounds like both sides are saying if given a bit more time, you might be able to work with some of these logistics, and Ms. Jefferson has indicated.
Yes.
On behalf of
Yes, Your Honor.
Yeah, I think that'd be fair, Judge, because that would be dispositive of this issue, and we'd be able to tell the court the disposition, once we've been able to sit down and actually do it with our clients in a physical form.
All right, very well. Ms. Jefferson, how much time do you think might be needed on this? I'm thinking 30 days out.
Right, 30 days out should be enough time because I think Mr. Washington gonna buy everybody dinner.
I won't make any commitments, but I will have my clients there and ready to go. Fair enough, Judge.
All right, very well. So we're going to give you a date, some 30 days out, Madam Clerk.
February 10th. I'm sorry, March 10th.
3/10, March 10th, 2022.
Let me
We're
check
going to
that.
set review on that date. March 10th, 2022. That's going to be at 9:45 a.m.
9:35,
Can we do
9:45.
9:45.
can we do the 11th or the following the 17th?
She said the 17th. You got a lot of cases on the 17th.
I got a lot of cases on the 17th. I can't do.
Do she want to do the What about the 9th?
You do the 9th?
I got trials on both days. That's the problem.
Oh, well, how about she want to switch it to the, who that, oh, I'm sorry, let me look. She can do,
You do the 15th?
yeah, she.
15th work for you, Ms. Jefferson?
Okay, well, can we do the 16th? I'm sorry to be a problem, Judge.
You said the 16th?
Right.
Okay. Yeah, go ahead.
Okay, so the 16th of March then, Mr. Washington, that works for you, okay, sir?
That's fine.
All right, 9:45 a.m.
9:45.
Thank you.
Ms. Jefferson, you and I will be talking today, this week.
Okay, thank you.
Okay, okay.
Good day.
Thank you. Okay, Ms. Wesley, Kenneth, and Bob, y'all can leave. Thank you.
All right, this is case number 16-1064. This is Modern Financial Services versus Deja Simmons. The matter is before the court. Just one moment here. On objections to a writ of garnishment. Do I have someone from Modern Financial on this matter?
Judge, sorry, Navjot Francis. Usually I cover for their office, but I don't see anyone here, so I don't know if they received notice for this hearing.
All right, looks like, and I don't have a complete file on this, but I think it's something to do with the fact that it's from 2016. Let me see, do I have Simmons on this? I think it's Deja Simmons.
Yes, sir, I'm here.
All right, good morning to you, ma'am.
Good morning to you, sir.
All right, this arises out of a judgment that is in place that was entered some time ago. And I think this is garnishment. Is this a garnishment against your wages, ma'am?
Yes, sir.
Right. And
Judge, could I make sure is the attorney of record Rolanda Mason?
yeah, nobody's yes.
Okay, I'm happy to stand in for her on this one, Your Honor.
All right, your appearance at this time for the record, if you will, counsel.
Sorry, Navjot Francis, P72322 on behalf of the plaintiff's attorney of record.
All right, thank you, Ms. Francis. And I have, all I have is the register of action on this file. I don't have the actual writ application or anything along those lines. So let me ask you, Ms. Simmons, has your wages been garnished? Has money been withheld already?
They started they started the process. They filed the last time I called my job to see if they started garnishing it was last week. They said they didn't start, but it could happen any moment. So
Absolutely.
that's what
Yeah, I was only asking to find out if they had withheld any money and how much was being withheld. So
no, they haven't started yet. No.
so 20, they would be taking 25% of your income, given the fact that this judgment is still outstanding. Why do you believe that they should not be able to garnish your wages?
Okay. So starting off, when I bought the car, I was up to date on my payments. Within the next 2 years, I lost my place. I'm not gonna go bore you with the story, but I don't have any paperwork from them. The only thing I got when I was going through my mishaps was that the car was sold at an auction, and they sold it for $8,000, and my balance due that I owe was $4,000. And I gave the car back. Well, I had no choice but to. They gave me a letter saying I don't have any of this information. This is all by memory, sir. So when I got the information that they sold the car in a police auction, they sold it and they got $8,000 for it. My balance was only $4,000 is what I remember. It was only $4,000. When I checked the ledger that I got recently, And when I called, because I had been in touch with them and I asked them if I could do a payment plan, they told me no, because it was already in court process, that they already issued a garnishment. It went up to 16,000 is what I owe as of right now. I don't believe that I owe the money. I only owe what was told to me, which was 4,000. So I do not agree with the balance that is on the car.
All right.
And,
Uh,
and I gave the car back. Oh, I'm sorry. Go ahead. I didn't mean to cut you off.
No, that's not a problem. I was letting you finish. Unfortunately, Ms. Simmons, all of those issues are not pertinent before this court because there's a judgment against you. If you believe, that the judgment is not proper, you have to file a certain type of motion or something to try to get that changed. As it stands right now, you have a judgment against you, and that judgment was entered on the 13th of October of 2016.
Okay.
$8,769.38. So that's the amount that the judgment was entered. To the extent that, listen to me carefully, to the extent that interest has accrued, the actual amount of that judgment could be more than that. And you do have the right to file motions if you believe that something went wrong. The biggest issue in this case is that there was no response to the complaint, and that the judgment was therefore entered by default. So what you're dealing with today is you're dealing with post judgment. There is pre-judgment stuff, there's post judgment. So it's the pre-judgment stuff, the court cannot address any of that today because that's before the judgment was entered. The only thing I can address at this stage is the post judgment stuff, unless you file the proper paperwork asking to be considered regarding pre-judgment stuff. So post judgment stuff is like a garnishment, and that's why you're in front of me. The plaintiff has a judgment, they want to collect on it. They're saying that we should have the right to collect on this judgment because it hasn't been paid. That's what we're dealing with today.
Okay. May I ask a question, sir? Or you're not done? I'm sorry.
Well, go ahead, Ms. Simmons.
Hey,
Oh, no, I want to ask, okay, so if I was able to do a payment installment, would you be able to grant that instead of them garnishing my wages?
Well, you're very wise in that inquiry, because obviously that is probably something that you want to try to do rather than allow the garnishment to stay in place. Now, you don't have a petition for partial payments before the court, but I will consider that today in light of the fact that there is a pending garnishment. Let me ask you, what would 25% of your take home be from your current job? Approximately.
I would approximately, I was just getting garnished and they took the same amount and I was only bringing home $400 a month.
Yeah,
Literally.
well, yeah, but you're not answering my question. My question is, how much did they take? Now, when you were being garnished, how much money was being taken per pay period?
They were taking about $400 to $600 a month.
Okay, all right. So that's and you're indicating that was some other judgment, some other case that you had.
Correct. Yes. Like this recently, I just had court with another garnishment, and they stopped my garnishment because I had to file. But yes, I had to ask them to lower my garnishment. They stopped the garnishment, but I had to make payments on my own. But I told the last judge, and I'm gonna tell you, I have 4 children, and I have a lot of bills. And that does not stop me from paying any money that I owe, because I'm not saying that I don't owe anything. I just I disagree with the money that I owe. But if I can start and make a payment, then yes, I'm willing to do that. But it will not be 25. I cannot, will not be. I cannot do 25% of my wages at all. Like not even a little bit.
If I leave the garnishment in place, that's exactly what you have to do. My point to you is that I want you to understand. I want you to understand the position that you're in right now. You know, automatically
Yes.
have an entire partial payment, and they got you. They somehow, it took a few years, but they got a garnishment against your wages right now. Let's talk about what you're willing and able to do. And a part of the reason I have to ask you that is because of the amount of the judgment. Again, you do have a right to file a motion at some point to address whether or not the judgment should be reconsidered, things along those lines. It's a high hill to climb, but you do have the right to file a motion to ask for reconsideration in that regard. But at the present time, I have to consider the judgment that's in front of me. And because of the
Okay.
amount of it, that affects what the nature of the partial payment can be. And so tell me, what did you have in mind as a monthly payment on this if you're paying voluntarily?
$100 a month.
Right, Ms. Francis?
Judge, if this, sorry, I don't have it in front of me, but if the judgment is $16,000, Judge, $100 a month is not going to cover the interest.
The amount, the judgment was entered on in 2016, and it was $8,700.
At 8,700 and 13%, I'm not sure what the balance would be at this time, but $100 still wouldn't cover the interest, even at $8,700, Your Honor.
Ms. Simmons, have you ever paid anything on this judgment, ma'am?
No, I haven't paid anything because I also moved. I meant to mention that I also moved. So I did not get the judgment that was given to me. You said, what date was that, on October? I mean, when was it?
Was it
January?
2016?
Yes, I did not get that. So
Yeah.
I was just getting, well, they were trying to garnish me and I didn't get anything of it. So this is honestly, this is my first time hearing for it because I told you I was going through mishaps in my life. So I was moving and I did not get anything. And the only way that I knew recently why I got it was because I called the court and I told you I had another garnishment. And the clerk told me, well, she said, you have also another garnishment that was filed on such and such date. So that was the only way that I knew
All right, ma'am.
that I had this garnishment.
All right, thank you. When I look at the documents here, I see that at some point service was allowed by publication because of the fact that they were not able to locate you, and that
Okay.
service led to the entry of the judgment. At this time, I will grant relief from the effects of the garnishment. Set up partial payment at $150 per month.
Okay.
I will have that payment to commence on the 18th. On the 18th of February, 2/18,
Okay.
$150 a month, and that amount is to be paid monthly during the pendency of this matter. And I'll suspend the garnishment in light of the monthly payment. As long as you make the payment, the garnishment will be suspended. But of course, if you miss any payment, they can reinstate the garnishment and get you back in the same situation. The amount that I've set at $150, the court deems it to be somewhat reasonable, given the amount of the judgment and the interest that is accruing. It is the court acknowledges that it's probably on the low end, but I've taken into consideration your income. I've taken into consideration the fact that you have minor children and the other issues that you raised. For that reason, I am setting the payment as I indicated, and you will get an order suspending the garnishment, but also requiring the monthly payment. Right. So I wish you well, Ms. Francis. You got that, ma'am?
Yes, Your Honor.
All right. Good day to the two of you. All the best.
Okay. I got one question. I'm sorry. So do I make the payment on the 18th, or do they just take? They're already gonna take it. I'm sorry. I just didn't hear the last part.
You'll have to make the payment.
Okay.
Sorry,
All right. Okay. That's fine. Thank you, sir.
Oh, 1 second, Ms. Francis, are you on another matter with me this morning?
I am. I have two others, Your Honor.
All right, are those default type matters?
Yes.
All right, so Ms. Simmons and Ms. Francis, I'm going to put you in a breakout room so you can make sure that you kind of go over where she sends the payment, who the payment is to be made out to, that type. So Ms. Simmons, I'm going to send you a notification to go to breakout room number 3 just so that you can talk over that, so that to make sure that you all set as to how you make your payments. All right, so. there's
Okay,
your
thank,
note. All right,
okay, thank you,
and
sir.
Thank you, and go ahead and click in, Ms. Simmons, to the breakout. There was nothing as found. Garnishment.
We have everything.
I got the order in protection.
Yeah.
So, it goes into- This is case number 21-160671. This is RMF Asset Management LLC versus Kenneth Alexander. The matter is before the court on an application for entry of default judgment. The record should reflect that the default of the defendant has already been entered where the defendant did not answer the complaint or otherwise respond to the proceedings in this matter. Upon the entry of the default, the court then set a hearing for the defendant to show cause if possible as to why the judgment should not be entered at this time. Your appearance for the plaintiff, RMF Asset Management.
Jack Francis, P72322, Your Honor, on behalf of plaintiff's attorney of record, and Mr. Alexander and I did speak and come to a resolution on this matter.
Right, and what's your name? Say your name for the record, sir.
Kenneth Alexander.
Thank you, Mr. Alexander. Ms. Francis, so you resolved this matter. What? Tell me what happened.
I did explain to him that a default has been entered and today's hearing was as to a default judgment entering. We did agree that the judgment will enter today and he will begin monthly payments of $200 per month beginning March 5th and by the 5th of each month thereafter.
Great. And Mr. Alexander, after discussing this matter, is that in fact your agreement regarding this matter, sir?
Yes, Your Honor.
And what's the start date on the payments on this matter? March
5th, Your Honor.
March 5th? All right, at
Yes.
$200. All right, so I will adopt the agreement and I'll sign the judgment in this matter. And I'll include in the judgment the language of the language regarding the monthly payments at $200 a month starting on March 5th. And I wish both sides well in regards to day two.
Thank you, Your Honor.
Thank you.
Day two. Mr. Alexander. The court calls case number 21-160-216. This is RMF Asset Management versus Rhonda Anderson. The matter is before the court on an application for entry of judgment by default. The default defendant has been previously entered where the defendant did not respond to the complaint or otherwise defend this matter. The court did set today as a date for show cause as to why, if any reason there is, why the judgment should not enter. Ms. Francis, you previously entered your appearance for RMF Asset. I'm looking now for Rhonda Anderson. Rhonda Anderson, if you're on the Zoom, please say something at this time. For Rhonda Anderson, a person living on Braille Street in the city of Detroit. It's appearing now that the defendant has now appeared for this hearing. This matter was set for 9:45. It's past that time. Accordingly, the court will enter the judgment by default on the application is made and will determine that there is due to the plaintiff the total sum of $966.03. The judgment is entered for that amount of court.
Thank you, Your Honor. I think that's all I had today.
That's all you have? All right. All right.
Thank
Well, good seeing you. See you again soon.
you as well, Judge. Bye.